What you have up in Sacramento right now is a 2/3 supermajority of, there's no other way to say it, progressives. And they really believe in taking away private property rights and redistributing that wealth. And in their minds, they believe that they're not asking for enough. And this is not a passive fight for them.
Hi, this is Chris German, and welcome back to the Apartment Dealer Show. This is the second part of a three-part series where we're discussing what were those recent bills that were signed into law by the governor. Let's dissect them. Let's learn more about them. How do they impact you and I? How do we need to pivot within the new requirements and restrictions? So Mike Brennan is rejoining us now, and he's going to update us. What do we need to know about these new laws? What do they mean when you read between the lines? And what, if we take a step back, a 1,000-foot view, what does it really tell us about where apartment ownership is headed in the state of California? Now, help me welcome Mr. Mike Brennan. So Mike, welcome to the show.
Thank you, Chris. How are you?
I'm doing well, sir. I'm doing well. We'll see how I'm doing at the end of this interview here. But so you were with us at our last live Apartment Owners Educational Luncheon. And at that event, you shared with the attendees not only laws that were sitting on Newsom's desk to be either signed into law or vetoed, but also trends that are beginning to, or have been in a movement for some time, and just what to be aware of those trends. Today, specifically, we're going to discuss, those laws that were either waiting for approval or veto, what passed, what should we know about them as landlords, so that we can prepare ourselves and we can pivot where necessary. So let's, in no particular order, but let's go through the ones that you feel should be highlighted for the landlords, and we'll give it back to you.
Okay, well, I'll start with the good news, and there is some good news. There were at least 15 bills that were not passed that would have had a negative impact on landlords. So it's sometimes by the end of this interview, it may seem like, oh my gosh, we're just getting steamrolled. And then to a degree, that's true. But there were a lot of legislative efforts this year, more so than any other year. And they ended up stopping a lot of the bad bills that were trying to get passed. A lot of the bills that I'm going to talk about today started off much worse than they really ended up. And it was through those legislative activities by various organizations that we were able to modify them to a degree where their impact is less negative than it would have been otherwise. So,
can I ask you a quick question on that point, Mike? Is with the legislators, like any good negotiator, are they just being smart and asking for more than what they really want, knowing that if they get 2/3 of what's being asked for, well, that really was the intention. And then over time, all you got to do is just continue to push the envelope. And eventually, you'll wake up and you'll have rent control, or you'll wake up and you'll have any of these various new laws.
I'd say 2/3 of what you just asked me is accurate. The 1/3 that I disagree with is that they know to ask for more and they'll accept less. I don't believe that's true. I think what you have up in Sacramento right now is a 2/3 supermajority of, there's no other way to say it, progressives. And they really believe in taking away private property rights and redistributing that wealth. And in their minds, they believe that they're not asking for enough. And this is not a passive fight for them, nor is it simply pandering. I used to say it's pandering. There's more renters than owners, and so they're pandering to their votes. That's not true anymore. These people are really zealots up there. And it's important to realize that California works on what we call a 2-year cycle. So a bill we were in year 1 last year. Now we're in year 2. We're entering year 2. A bill that didn't pass last year can easily be brought back this year. Then if it doesn't, meaning this year, meaning the 2024 year. And if it doesn't pass then it'll have to be gutted and brought back the following year as something different. So no, it's not them asking for a lot more, hoping to get less. It's them saying, hey, we're being nice to the private property owners. We want more than what we're asking for, but we'll settle for what we've got. It's really that crazy.
Wow. Okay.
All right. So we'll start with Assembly Bill 12. That's the one that deals with security deposits. And we talked about trends, or you brought up trends. And I just did a whole trends seminar. I've done it a couple times now in the past couple of weeks. And one of the trends that I brought up was the legislators in Sacramento are trying as hard as they can to limit the ability of the landlords to screen tenants and to limit the ability of landlords to have a substantive decision on who they take and how they take them. And so AB 12 is an example of that. It's a limitation on security deposit. It goes into effect July 1st, 2024. And what it says is, regardless of whether the apartment is furnished or unfurnished, the maximum security deposit a landlord can accept is 1 month's rent. So, and before a lot of your members will start trying to get clever about how do we do this? Oh, can we call it something else? No, you can't. There's a lot of case law on this that specifically says it doesn't matter what you call it. If it's payment that is not being paid directly towards the rent, it's security deposit. You can call it key deposit, you can call it pet deposit, you can call it whatever you want. The case law says it's all security deposit. So the absolute maximum you're going to be able to ask for is 1 month's rent starting July 1st. And where I think that the intent of this, the stated intent was, hey, look, people don't have the money to come up with 2 months rent. And that's probably true given the state of the economy. But really the impact of this is going to create more difficulty for the tenants in that a lot of landlords, and I've done it myself, have used the ability to take 2 months rent to accept somebody that otherwise they may not have accepted because maybe a low FICO score or a debt that hasn't been paid off. And so now landlords are simply going to say, we're not doing that. They're going to raise the FICO score and say, if you don't have a minimum FICO score of this, you don't qualify. And they'll just sit on a vacant unit and wait for that unit to be occupied by somebody who does.
Now, what about existing tenants? You have an existing tenant, you're sitting on, say, 2-3 months security deposit. That is still all okay. It's just anyone new after July?
Correct. Yeah, you don't have to, as far as I've read so far, you don't have to give back those security deposits.
And is that the 1 month security deposit, is that all inclusive? Does that do away with additional security deposits for pets?
Yes, that's what I was saying. Maybe I wasn't.
Wow.
You can call it whatever you want. You can call it a security deposit plus a pet deposit. What the law said before was you have to combine both that security and that pet deposit. And the maximum you could take was 2 months rent. There's some exceptions. You could get another 2 weeks of rent if they had water-filled furniture or something like that. But that was the maximum. Now you can call it security deposit pet rent all you want. You're still maxed out at 1 month's rent.
Wow.
That's a great transition into another law that passed is, let me get the number real quick, but this is for new construction, by the way. It's unbundling of parking. This is AB 1317. So the reason this becomes important, this AB 1317 said for new construction beginning next year on 16 units or more, landlords are required to unbundle the parking from the rent. So what's the effect of that? Well, it reduces what your base rent amount is. And so you'll only be able to collect 1 month's rent for security deposit. So that unbundling of parking for new construction is going to actually reduce the amount of security deposit. So, but the upside to that for a landlord is I actually like unbundled parking because while they may be able to control the housing, the residential component of things, if you unbundle that parking, now I've got a commercial lease for parking. I'm going to lease that parking out on a commercial lease. And I'm going to be able to charge whatever I want for that parking. And as we all know, most people in California have multiple cars. They need parking. And so that's going to be an offset to the rent control until they figure out some other law to take that away as well.
And that's for only new construction, 16 units or larger?
Correct.
Okay, got it.
So going back to it again, this security deposit issue is another way for to limit a landlord's ability to really decide which tenants are in there. If everybody's just going to get 1 month security deposit, then we can't use 2 months as a way to get in a better qualified person. All right. So that's Assembly Bill 12. Then we move on to Assembly Bill 548. This one is an inspection bill. And basically what it does is it requires local enforcement agencies to develop some policies and procedures about inspecting multifamily properties. The problem I have with this law is it gives that inspector the right to inspect any unit they want. Even, let's say unit number 3 called and complained, and you've got, let's say, an 8-unit building, and the inspector gets there and goes through number 3 and says, you know what, I think I want to see all 8 units. It gives them the right to do that. And so it could be problematic. I don't want to overstate that. We'll see if that happens. Inspectors are generally pretty busy, and unless they've had multiple complaints, I don't really see them abusing that kind of authority unless the landlord finds a way to upset that inspector.
Right. Rub on the wrong.
And I can tell you exactly how that happens because I've deposed inspectors, I've met with inspectors, I know inspectors. Typically, the way to anger an inspector is for an inspector to come to the property and say, hey, these are the things that need fixing. And then when they come back for that reinspection, for them to find that either you haven't fixed it or you've put a Band-Aid repair on it. If you don't do it right and you upset that inspector, I guarantee you they're going to start finding things that weren't on the original inspection. And now it looks like they're going to have the authority to say, okay, now we're going to go through all of your units. So keep that in the back of your mind when you get some sort of a violation.
Got it.
All right, so that's AB 548. That one goes into effect January 1st. Then we've got Assembly Bill 1317. This is the unbundled parking. I just talked about it. New construction, 16 or more units. Those properties will be required to unbundle the parking.
And that's effective when?
I don't have it in my notes right here, but I would assume, unless I say otherwise, just assume it goes into effect January 1st.
Okay.
Then we've got Assembly Bill 1418, and this is an interesting law. So most cities, their city prosecutor and their police departments have on the books the ability to tell a landlord, hey, you've got a tenant that is a known gang member, or they have gang affiliations, and we've had to come to the property too many times. We've had to arrest them. They've had interaction with the law. And so we want you, in fact, we're forcing you to evict those tenants. I've done a lot of those evictions. And typically what the city says is if you don't evict that tenant, we're going to prosecute you. And this new bill basically limits them and tells the cities they cannot have those policies anymore. They can't create any sort of a policy or procedure that creates a negative interaction with the tenant merely, as they like to say, merely due to the fact that that tenant or somebody in that tenant's unit, the tenant's unit has had negative interaction with the law enforcement. So again, you've got a tenant that's a problem, or somebody in that household is a problem, and the state is now limiting your ability and the city's ability to terminate that tenancy. So I want to stop here for a second. And over the years, Chris, you and I have been doing this. You've seen a lot of themes emerge, and you and I have had private discussions about this stuff. The theme here is take away a landlord's right to get rid of bad tenants or to get rid of any tenant. Just keep whittling it down. Landlords have no right to remove any sort of a problematic tenant in their building. That's the goal. So what's driving that goal? What do you think it is that's driving that goal, that the legislators think it's wise to remove a landlord's ability to remove problematic tenants?
It seems on its face they want property ownership to become that much more complicated, that much more burdensome, so that then one thinks twice before purchasing multifamily properties. Or if you currently own, you start thinking more heavily, maybe I sell, go somewhere else, do something different. Because if it's not that, then what could it possibly be where they're saying, we want you to keep criminals in your building, essentially?
Well, I think you're absolutely right. They want to drive out the smaller owners and drive all the properties into larger owners who have economies of scale and can navigate this stuff more efficiently. And I won't go too deep into this due to time constraints, but you and I have also talked about technology, how fast it's advancing, AI, how many people are going to be out of work, and how hard it's going to be for people to really be able to afford to pay their rent. And the city and the state are looking at that, 20 years down the line going, we don't want, people just homeless laying out in the street because they don't have places to live because they don't have jobs. So it's just something for your members to think about. Where are we going with all of this stuff? Okay, so AB 1382 is slightly different. This is a new law that requires local jurisdictions to create a program for the pre-approval of ADUs. So again, we're talking about housing. So if you think about it, that kind of ties into the theme we were just talking about. The cities and state are trying to do everything they can to facilitate more housing and to keep people housed. And so this new one, 1332, basically allows a city to create a fast track process to pre-approve these ADUs. The problem with the ADUs, and many of your members will have already figured this out, is you may have a single family home that is not subject to rent control because it's a single family home. And the minute you put that ADU on the property, that changes the whole dynamic. And now you've got rent control on that property. So, and that's not true in every instance because many of the rent control ordinances state that it only applies to a building that's built after a certain year, but it is certainly true with all of these just cause ordinances. So you have people call them both rent control, but it's not. It's different. Rent control is the ability to cap rents controlled by Costa-Hawkins. Just cause is the ability to evict these tenants, and there is no date limitations on a just cause. So as I said, the minute you put that ADU on that property, not only are you subject to rent control potentially, but your property is now falls under these just cause ordinances, and it becomes very difficult. So for any of your members who are thinking about putting an ADU on their own personal property, I would think carefully about that before I made that decision. You might be stuck with a tenant on your property living in close proximity that you have a lot of difficulty.
Right. You just gave up your rights, right?
Yeah. Okay. So we talked about AB 1418, Assembly Bill or AB 1607. So this law is interesting. This is the right, I call it the right to counsel law. This law basically allows local governments to adopt new laws and policies and ordinances that transfer tax revenue into various housing programs. Now, one of them, LA, has been toying with this. I think the only reason they didn't pass it is because they knew the state was going to be passing this, and now they'll start looking at this more seriously. But essentially, it allows these local municipalities to create these programs that fund private attorneys to represent tenants in evictions. And you may remember at not this last luncheon, but the luncheon before, I probably brought up the fact that there was a proposed constitutional amendment that would have made housing a fundamental right. That actually did not pass. But if it were to become a fundamental right, this is exactly how that would play into it. Once it's a fundamental right, then they have this right to an attorney. And you can imagine where that's going to go. I can tell you from personal experience, and I think I mentioned this at your luncheon, in the last 6 months, there used to be the big 5 law firms that represented tenants. It was Eviction Defense, Basta, Legal Aid, Public Counsel, and there was one more, and I can't recall their name off the top of my head. But, Betzetic. But now, in the last 6 months, there are hundreds of law firms we're getting answers filed by all of these law firms we've never heard of. I looked them up. They've never done landlord tenant work before. And so the word is already out that this has passed. The word is already out that, they're going to be receiving their funding from the state and from the local municipalities. And so you're starting to see all these law firms ramp up. And let me explain why that's more dangerous than it may sound. Free attorneys for evictions is bad enough. All they do is, let's talk about evictions first. Free attorneys for evictions accomplish one thing, and that is the exact opposite of what a landlord is trying to accomplish. When you have a tenant that's either a problem or not paying their rent, your goal is to get that property back yesterday and get it cash flowing again. Their goal, these tenants' rights attorneys, is to keep that tenant in there as long as they possibly can, not paying rent, so that they can save the money and get them out to another place with a sealed record and a waiver of all that back rent. That is their goal, right? Okay, fine, we accept that as the goal. But that, in the end, that's all they ever accomplish is that waiver of rent, the sealed record, and keeping that tenant in there for, let's call it 2 to 3 months, that they wouldn't have otherwise been in there. That will be changing now. So we're going to shift from evictions over to affirmative lawsuits. What do I mean by that? Well, all of these municipalities are starting to develop these anti-tenant harassment laws, or maybe it's called tenant anti-harassment. That's what it is, tenant anti-harassment law. And they all have, most of them have provisions in there for attorney's fees. As these just cause ordinances pop up in the various cities, they all have provisions for attorney's fees. And they specifically state a landlord who's violating this is in violation of the ordinance, and the tenant has a right to a civil lawsuit, et cetera. So all of these law firms that are starting to pop up in the eviction realm, your members can anticipate that their exposure to lawsuits and liability is going to increase in a short amount of time. In the next few years, I imagine we're going to be seeing a lot more affirmative suits against landlords for allegations that they violated the just cause ordinance, or they violated the rent control ordinance, or the anti-harassment ordinance, something along those lines. And the reason for that is because that attorney knows that the landlord's just going to throw that over to their insurance company and they're going to get a settlement check.
Yep.
And as you and I both know, and your members know, the problem with that is the insurance companies are leaving California. It's next to impossible to get an insurance company to provide coverage in California for multifamily. And when they do, all they're doing is putting you into a high-risk category and jacking your rates up 3 to 4 times. So that in and of itself, this right to counsel, is going to create long-term problems down the line. This next one is really interesting. It's Assembly Bill 1620. And what this basically says is any city or municipality that has a rent control ordinance in place can now require a landlord, they can create a new law that says when a tenant who is disabled in your property requests a unit on a lower floor, that you will be required to accommodate them and give them that unit. And the way they've worded it is as long as it's a comparable or smaller unit. So in other words, they can't move from a 1-bedroom to a 3-bedroom simply because they're disabled, but they could move from a 2-bedroom to a 1-bedroom downstairs. Now, the challenge with that is going to be, you can probably already guess where I'm going. What do you do when a tenant moves out and you rehab that unit downstairs, and the disabled tenant upstairs they've been there 20 years, their apartment is absolutely trashed, and now they want that brand new remodeled 1-bedroom downstairs? Are you going to be required to give that to them? Well, we'll see. I've read the ordinance, but I haven't come to a firm conclusion on whether that's going to be a requirement yet, because it says comparable. And so my argument at this point is that that's not a comparable unit. Mm-hmm. Comparable unit would be a unit that's been lived in for 20 years. And I've just remodeled this unit, and that makes it uncomparable or incomparable. And obviously there's a huge loss to the landlord there between it. If there are similar units, let's say they're both 1-bedrooms, you've got a unit upstairs that's going to take, on the low end, $3,000 to $5,000 just to clean it up. If they've lived there 20 years, you and I both know the numbers are going to come in more around a $10,000 mark to upgrade that unit. And now the tenant's going to get that unit downstairs that's already been upgraded. So, it's a huge loss. So very interesting bill. We'll see how that one plays out in the case law. All right. The next one is another tax bill, County of Los Angeles Transaction and Use Tax. This is Assembly Bill 1679 by Santiago, and it allows the city and county, I apologize, it's just the county, to impose a higher transaction tax, that TUT, that transaction use tax that we've heard so much about. And basically it's allowing them to exceed their 2% statutory limitation. So as going back to that theme about technology and AI and people losing their jobs, as that happens, cities, states, and countries lose a tax base. And over the next decades, as that occurs, you can imagine that every city, every local municipality, every state, every country is going to be looking for ways to increase their tax base because they're losing taxes. In fact, you guys can mark this day on your calendar that Mike Brennan said this. As the AI advances and people are losing their jobs and they can't, the older generation, the people who are, I don't want to state a specific age, but they're at an age in their life where it's difficult to retrain them for some other job other than something menial. That tax base is going to diminish rapidly as AI advances. And so you can expect these municipalities to start looking for other ways to increase their taxes. And one of the ways they do that is they vote to lower, or they pass laws that allow them to lower the threshold of votes required to pass a tax. So oftentimes taxes require a 2/3 vote up in Sacramento to be passed. And we'll get to it a little bit later, but there are, over the last, decade, I've seen multiple bills passed that in various areas, it allowed the legislators to reduce that to a simple 51%. And we've seen just a whole slew of new taxes being passed on everybody. And so that's the state's base way of maintaining their tax base as technology displaces people.